Respondent.
Thank you, my Lord. Just to orientate myself, just before the short adjournment, I was making submissions as to the absence of relevant evidence from which the court could conclude that paragraph 17 was not an appropriate solution to the upgrading and sharing rights. And I'd made the point that there was no evidence that the appearance was irrelevant, and I'd made the point that there was no evidence of what was likely to happen over the course of the new lease, so that it was impossible to engage with what kind of prejudice might follow from any changes. And the third was that there was no specific evidence of the effect on the business of On Tower of being subject to the paragraph 17 conditions, the two constraints in paragraph 17. And where I finished just before the short adjournment was that so far as the historical evidence is concerned, the relationship has been entirely harmonious and has not caused any difficulties and has run for 21 years now. That, I suppose, is not germane to what should happen in the future. So what was the evidence as to the future? Answer, there really wasn't very much, if anything. An important part of it was that a lot of it would depend on the requirements of On Tower's customers, i.e. the mobile network operators, or MNOs as they are in the jargon. And we can see that in the second supplemental bundle. Sorry, the first supplemental bundle, that's the second bundle, from the evidence of Miss Sarah Burrows behind tab 7. Paragraph 28, this is on page 76. She says, well, 27 says that Mr. Hawley, I hope I pronounced his name right, Mr. Hawley outlines the government's aims and so on. And then she says, to meet those targets, the demand for improved services, the rollout of 5G technology will involve making improvements. And she puts that in 3 to 5 years' time for 5G. And then this comment, at the end of 28, it will ultimately be dictated by the needs/demands of the MNOs. So from that, one immediately says, well, what's the evidence from the MNOs as to what's likely to happen? Answer, there isn't any.
Can I ask you one specific point in relation to this? We can see 5G is coming, expected to fall in the second wave in approximately 3 to 5 years' time. If you get the lease that you think should be granted, what does On Tower do in 3 to 5 years' time?
It gets the right to upgrade.
And how does it do that?
It upgrades. So long as it complies with the two conditions. So no further...
Can it? Even though on this basis you have already got an agreement and that has not expired, it can apply for new rights.
Not applying for new rights. These rights will govern what it can do. So if the right is to be able to upgrade in, say, 3 to 5 years' time when it needs to upgrade, it's entitled to do that. The only issue is there going to be some unpleasant visual change to the apparatus from that? If so, you can't do it. Or if there is going to be prejudice to the enjoyment of the property by those enjoying it, or some loss and damage to those affected, then you won't be able to do it either. But if you can solve either of those things, you have the absolute right to...
Both of those things you've got.
Both of those, sure.
And to be clear, it isn't, at least as the law stands, possible for On Tower to come back to the court or to the tribunal. It's stuck.
At the moment, that seems to be right. I suppose the court could order a possibility that it come back on particular circumstances if circumstances change. I hadn't thought of that, but But the essence of the jurisdiction is to set a new agreement which is going to govern whatever the term is that is awarded by the court.
And if there's a dispute between the parties about whether this will have a more than minimal effect on appearance, then I suppose a court will have jurisdiction to determine.
Yes, because that will just be under an agreement,
Yeah.
a code agreement between the two parties.
I mean, to be clear, that would only be the case if that had been conferred by agreement. There would be no right under the code to come back.
Yes, I think that's what I understood your lordship to be asking me, and
Yes.
I was trying to confirm that my understanding is that there would be no right to go back under the code.
Yes.
The point being that the right to modify, which is really what we're into here, is a right which only arises after the end of the current term.
Yes.
So if the court has ordered a 10-year term and this issue were to rise after 5 years, you don't get into modification.
And the same with upgrading.
Yes.
Unless you could satisfy the paragraph 17 conditions.
Yes. I mean, there are sort of break clause options which could be introduced. Say if such and such a thing should happen, then you can break, and then you will be able to apply for some modified terms. But offhand, that's the only way in which I think
Yes.
you could deal with it. The point I was making here, though, was that looking at the future, we simply don't have any evidence upon which to begin the assessment of what likely prejudice there is to anybody on the site provider's side, nor as to what the effect of the visual appearance would be of any changes. And Ms. Burrows is suggesting that this is going to depend upon the needs or demands of the MNOs, who are essentially On Tower's clients. But then we don't have any evidence from the MNOs as to what it is they envisage they're likely to want to do or want to have done with any of the equipment that will be on site pursuant to this agreement. Really, her evidence is rather thin in this respect, but that's the section in which to find it. Mr. Hawley has more sort of technological evidence in his, which is tab 8 in his witness statement. One interesting thing to note in passing on page 95, as to the rapidity of changes that might be contemplated. 2G, this is at the bottom of the page under technological change. He gives a potted history of the major events. 2G was 91, with updates after that. 3G has been with us since 2003. 4G in 2012. They haven't remained static as capacity improvements were made during their respective lifetimes. 5G is being rolled out now, and once rolled out is also unlikely to remain static. But 5G isn't even, on Ms. Burrows' evidence, an immediate prospect. Her evidence is 3 to 5 years before anything needs to be done on this side. Otherwise, on Mr. Hawley's evidence, it might be worth just checking what he says from paragraph 101 onwards, under the heading, the site provider's proposed restrictions on sharing and upgrading. If your lordships and your ladyship haven't had a chance to read that yet, I'd invite you to do so. The point is that there is nothing specific to paragraph 17 there. It's a general complaint, or a general expression of how you need sharing and upgrading rights, but without exploring the actual issue between the parties, which is, can you have those rights, or can you implement those rights without compliance with the two conditions in paragraph 17? In other words, does paragraph 17 cause you any particular difficulty? So the specific issue is just not addressed, other than in the most general terms about wanting flexibility. So we end up with this position that On Tower, as a whip, is getting a much better deal now as a result of the new code, because no consent is required to any changes, and no pay away is allowed for any sharing rights. And so it takes full advantage of the code. And my rhetorical question is, what protection is left for the site provider in those circumstances if the paragraph 17 protections are to be excluded? The site provider will remain entirely at the mercy of whatever changes the On Tower or its MNOs would wish to make. And our submission is that that creates essential unfairness between the parties for the purposes of a Part 5 application, in the light of the uncertainties as to the future technological development and future requirements of my friend's client's operations. There's this point also, which is, if a whip is able to come to this court or to the tribunal and say, well, I shouldn't be obliged to explain what I need because it's all in the hands of the MNOs and they will be driving whatever changes, then we're getting to a position that the whip is treated more favourably than the MNO would be treated if it was the MNO who was making the application, from which one can immediately divine that MNOs will reorganise themselves so that there is a whip to put up to ask for all the rights and then subcontract them, as it were, to the MNO, which is sort of what's happening anyway, but that is the effect of allowing the whip a free hand merely because of its business requirements.
Might that be a good thing in public interest terms because it encourages more sharing and fewer masks?
Yes, but the public interest, it could do. And indeed, the business requirements could well require that. And I don't dissent from any of that. The point is, where's the balancing exercise? If in fact this code was intended to operate as you go along, you a whip or an operator can go along to the court, ask whatever you like, and it gets given to you. What's the point of any of this? Answer: it's not. It was intended to be a balanced exercise, as Lord Justice Davis put it in the Ashlock case. And that is an important corrective to all the statements as to policy which underlie my friend's submissions. There's one other point I might make in answer to your Lordship's observation there, which, could we go to the authorities bundle? Just the DCMS report, Department of Culture, Media and Sport report, is the last tab 15 of the bundle. And if one goes to page 342, there is the formal government response. This is in the context of this consultation paper. The formal government response on upgrading and sharing apparatus. And we've sidelined some passages there, but in the second paragraph, it said the government will provide an automatic right for operators to upgrade and share apparatus without prior agreement or payment to site providers where there's minimal adverse visual impact. This change will play an important role in enabling operators to quickly update their networks when new technology becomes available and help facilitate more efficient use of infrastructure through greater sharing. Both of these impacts are likely to have a positive influence on investment and ultimately lead to better outcomes for the consumer over time. That's the point, essentially, that your Lordship is making to me, but it was dealt with by the government, or it was reflected by the government, by making a paragraph 17 provision, and then dropping down the same box to the last paragraph. Second, in order to address concerns about terms that could be perceived as too broad and subjective, the government will remove the reference to inconvenience in the new power. That's the old code language. Our assessment is that the remaining conditions, including adverse visual impact and additional burden, are required to provide adequate protection for site providers when operators exercise this new code right. So this is not incidental. This is one of the reasons, I suspect, why the Lands Tribunal of Scotland was forthright in saying, well, the government has set this as a standard. And this kind of language, that the additional burden and the adverse visual impact are required to protect site providers, shows that the Land Tribunal of Scotland was on the right track. So, my lords and my lady, if I could just conclude, therefore, what we're looking at is, what we should be looking at is a degree of fairness as between a site provider and an operator. And if the effect of the clauses sought by On Tower is to open up an unrestricted right of upgrading and an unrestricted right of sharing, then that is effectively opening up the site provider to all the consequences of the current uncertainty as to what is to happen on this site. And in the end, my submission is that that is simply not a fair conclusion to reach on the facts of this case. So unless I can be of assistance, that's my submission.
Thank you very much, Mr. Pyman. Mr. Radegan.
Thank you, my lord. My lords, my lady, I was trying to think of the best way of putting structuring the submissions. I think that the best way is to, first of all, try and give the court a slightly wider view of the policy issues underpinning this particular area of law, but secondly, focusing on matters which my learned friend has dealt with only really rather briefly, which is the actual reasoning of the Upper Tribunal and the issues that it was called upon to determine. It's worth reminding oneself that what my learned friends are trying to do here is to challenge the exercise of a judicial discretion. And in order to do that, they're going to have to show that that judicial discretion was infected by a relevant error of law. Not just that there might be an error of law, but that it has a relevant bearing on the decision-making processes and its outcome. But before I explore why, or rather what was an issue before the tribunal, which was largely common ground as to the issues between the parties, I just wanted to first of all draw the tribunal, the court's attention to certain policy aspects of the code and a few provisions of the code that my learned friend hasn't taken you to. I'll try not to, of course, repeat what my learned friend has already said. The Law Commission Report 336 and the DCMS document you've just been taken to make clear that the point of the code is to provide a fast and flexible statutory mechanism for the rollout of new technologies. The Law Commission explicitly drafted the code so as to be, in their phrase, technologically neutral. That's to say, it wasn't meant to prescribe particular forms of technology, but simply be able to adapt to whatever it is that the ingenuity of the electronic communications sector can devise. Thirdly, given well-known issues like the lack of a rollout of rural broadband and 4G services, the policy of the code was also to drive down the costs of doing so. And in so doing, controversially it's turned out, but in so doing, Parliament made the decision that the valuation of code agreements under the new code should proceed on a specific valuation hypothesis contained in paragraph 24, which we'll have to come back to when we consider paragraph 17. But in very bald terms, paragraph 24 introduced two relevant assumptions, the first of which my Lord Justice Newey identified, which was the no network assumption. In other words, in the hypothetical valuation world, one assumes one is valuing the right to keep inert apparatus on site. And the second is a no scarcity assumption. In other words, even if this is the Cinderella site, it's not too far, it's not too near, it's not too tall, it's not too short, or rather the Goldilocks site, I should say, there is no scarcity value to be attached to that. And the idea behind that, as this court decided in a case that isn't in the bundle of authorities, but in the University of London case, one of the points of that was that there should be eliminated any ability to claim ransom from operators who are in need of this particular site in connection with their network. Now, that's material because picking up on the observations made to the end of my learned friend's submissions, as matters stand, a lot of these cases have been about site providers, for understandable commercial reasons, trying to find ways in which operators can be required to transact with them outside the code, because the code has had this depressing effect on consideration payments. And one of the areas which has caused difficulty, which will be detaining the Supreme Court in February, is the fact that the law in its present state has reached the condition that an operator who is in occupation, whether that occupation be under some legal right or whether that occupation be under the right not to be removed under Part 6 of the Code with no positive right to remain, an operator who is in occupation in those circumstances can neither negotiate for a code agreement under Part 2 of the Code, and nor can it return to the Upper Tribunal for a top-up or additional or different right. It is stuck, as the law stands, with whatever rights it has secured at the initial negotiation. An operator in such a case, therefore, in all of these renewals and all of these new right claims, is attempting to ensure that the agreements are future-proofed and permit it to carry out its commercial activities with a reasonable view as to what might be required in the future. So that is one feature of these cases. The code was also introduced against the background of an innovation in the industry. Which
just before you go on, I had picked up, as you'll have gathered from my discussions with Mr. Claimant a moment ago, that the operator couldn't go back to the tribunal. You say the operator can't even enter into a consensual agreement.
They can enter into a consensual agreement, but that would unfortunately not be a code agreement.
I see.
Because not with occupier. So that the transaction, the voluntary transaction that could be entered into, if for example what is sought is not a mere variation, which are permitted, but if what is sought, for example, would be an additional right or further code rights to be conferred, the person who one is approaching as the occupier, the person who one is approaching that transaction cannot confer additional code rights, for example.
And if you wanted to change your mast, is that an additional code right,
well,
or is that a modification?
There are different degrees, but certainly, for example, I can illustrate perhaps what the attitude of a site provider would be by reference to this case. In this case, the site provider wanted to maintain a practice that had obtained under the old code, which are so-called equipment caps. If one looks at an old code agreement, what you will see in the schedule is that there is a permission to install a 15-meter mast and no more than 6 antennae. And the whole object of that exercise is that if the operator in that circumstance wishes to install a 7th antenna, that then has to be separately negotiated for and paid for. But if, as we must assume for present purposes, Compton Beecham is right and Ashloch are right, then that negotiation does not take place against the background of the ability to go under Part 4 to secure those rights by imposition under the beneficial to the operator valuation hypothesis. That happens on a ransom basis, if you like, or at least on an outside code basis. That's the difficulty that is faced by if, for example, equipment caps which have fallen out of fashion in the tribunal were to be reintroduced. It would set the site in aspic and require there to be a negotiation outside the code. And what's more, of course, also, if the agreement conferring the purported code right is not within Part 2, all of the protections that come with a Part 2 agreement, exemption from land registration, automatic binding of other people with interests in land, the deemed lawfulness provision for the exercise of code rights, none of those would then be engaged as a matter of statute. So that's the third policy, this idea that one has access to a cheap, a relatively quick, specialist tribunal jurisdiction, which is able to impose agreements relatively fast on a variety of specials valuation assumptions. But the fourth feature of these reforms, which is relevant to this appeal, is that the Electronic Communications Code, in its new form, recognised for the first time a new species of operator. The old code was very much rooted in the privatisation of the telecommunications industry in the 1980s, and thereafter the ingenuity of the sector was such that it became clear that rather than every operator setting up its own mast site, capital costs could be saved if mast sites were shared. And that is, as has been already observed, also in line with planning policy in Scotland and in England, both having planning policies that encourage the sharing of infrastructure to avoid the multiplicity of masts. The Law Commission was aware of this feature of sharing, but was also aware that sharing is often facilitated by what my learned friend has accurately described as WIPs, wholesale infrastructure providers, who themselves come in two flavours. One is a wholesale infrastructure provider, which is the shareholdings in which might be vested in 1, 2, or 3 more mobile network operators, MNOs. And until a recent sale of the business, Cornerstone was an example of that, for example, which primarily operated for 2 mobile network operators. The respondent in this case is a WIP of the second flavour, which is, in the terminology of the trade, a neutral host. And what is done by the respondent is that the respondent identifies an area in which there might be a need for it to install its totally inert apparatus, a mast, a concrete plinth, and other inert infrastructure. And that mast then does nothing unless and until it is brought to life by either a network operator or the RNLI or the Emergency Services Network or some other entity that has a need to make use of the mast. Now, that's not to say that they're built speculatively. They're obviously built in relation to sites where there is a demand. But the idea of a neutral host is that, subject to the technological limits on the site, the configuration of the site, the size of the site, and so on, that mast is in principle available to any operator who has a need for it. That statutory purpose was explicitly recognised under the code. I'm working from what remains as accurate in the book that we wrote about the code, but which has now been largely overtaken by decisions of the court. But the actual code itself, your lordships and your ladyship should find behind tab 13 in the authorities bundle. And the part of that code that I invite you to is part 1. And without repeating my learned friend's paragraphs, which I'll take as read, I would invite the court to focus first on paragraph 2, which defines the operator and who is the operator under the code. And it provides that this code, where this code is applied in any person's case by direction under section 106, that person is an operator, and alternatively certain emanations of state are automatically operators. We're not concerned with those. The direction and the reference to section 106 is a reference to 106 of the Communications Act 2003. And essentially that is a process whereby a person or a company seeking to acquire operator status has to apply to Ofcom for a direction that it may exercise code rights, and Ofcom then conducts a public benefit analysis as to whether that status should be accorded to that operator. And there's a consultation process and so on and so forth. An operator can only acquire and exercise the paragraph 3 code rights for one of the 2 recognised statutory purposes in paragraph 4 of the code. And in paragraph 4 of the code, the 2 statutory purposes are either the provision of their own network, that's the MNO, or for the purpose of providing an infrastructure system, that's the WIP. And the rights must be exercised for those purposes. And the operator is an operator only for those purposes. Infrastructure system is further defined in paragraph 7, in this code, infrastructure system, this is not the best definition, means a system of infrastructure, but then it goes on to say provided so as to be available for use by providers of electronic communications networks for the purposes of the provision by them of their networks. So the whole, it's not just the business function that my learned friend is referring to, but it's also the statutory purpose, the reason for which my client, for instance, has a 106 direction, is that it can only acquire code rights for the purposes of providing an infrastructure system, and that infrastructure system must be available for use by other MNOs and other types of maybe non-operator broadcasters like the RNLI or the emergency services. Now, that's the fourth limb of the policy, that there has been a clear policy decision to encourage operators like the respondent in this case to acquire code rights for the purposes of sharing, and sharing is only possible because what is provided is an inert tower with no signal beaming from it. Sharing is only possible by such operators if those towers are brought to life by MNOs coming to them and installing their antennae, their equipment cabins, and their cabling, and so forth. So that's the policy background against which the specialist Upper Tribunal Lands Chamber is exercising its various jurisdictions under the code, and that's all well recognised in the cases in tribunal and in this court. The second general point I'd like to make is this. At the heart of the appellant submissions is that the code agreement should only ever have been pegged to paragraph 17. In other words, the submission being made to this court is that it's paragraph 17 or nothing. Now, the first point to make in relation to that is that is, of course, itself also a change from the terms of the existing agreement which is being sought, because we'll see that the existing agreement is actually rather wider than that. But the second point is that, bearing in mind that the application here was made by a WIP, neutral host WIP with the statutory purposes it has, paragraph 17, if imposed in the terms advanced here in this court by the appellants, would offend each one of those four policies, and it would operate to chill those four policies. It would prevent rollout, because it would prevent the acquisition of new code rights, because Part 2 and Part 4 wouldn't apply if new code rights are needed. It would offend the principle of technical neutrality, because my learned friend appears to be suggesting that there has to be spelt out at the beginning of the 10-year term what apparatus will be on the site. It offends the principle of no ransom, because there will be a ransom to the extent I've indicated. And it offends the principle against sharing, because it means that the mechanism of sharing, which occurs through allowing MNOs to install their apparatus on site and thereafter to share, will necessarily involve activities going beyond what paragraph 17 countenances.
Is that necessarily obvious? I mean, might it not be that you can do a lot of these things while complying with the conditions?
My Lord, the problem is, if one looks at perhaps the way I should start is to explain what paragraph 17 is doing in the code. One of the big problems in negotiations between site providers and operators, and in cases between site providers and operators, is that site providers look at paragraph 17 and they say, that's it, that's your lot. And they read paragraph 17 not as a beneficial right conferred on an operator, but as a restriction imposed on an operator. They treat it as a ceiling, even if they accept it's a floor. The operators on the other hand, say, well, look where it sits in the code. Paragraph 17 is part of Part 3 of the code, and Part 3 of the code sets out matters that are consequential upon the entry into any code agreement of any kind whatsoever. They are not terms of the code agreement, they are consequences of the entry into the code agreement. And what paragraph 17 was specifically was an assessment by the Law Commission in Law Com 336 of the extent to which without asking for them or indeed paying for them, an operator should be allowed to alter, upgrade or share its apparatus without thereby having to get any special consent from the site provider. And the debate in Lawcom 336 was that it was suggested that maybe those automatic rights should be unlimited. And what the Law Commission said was that the automatic right, not the negotiated right, but the automatic right any operator gets as a consequence of acquiring code rights under an agreement can only go so far that they are, in effect, if I can put it this way, no skin off anyone's nose if exercised. That is the furthest that the Law Commission was prepared to go for automatic rights. And that is clear. If I could invite the court, please, to turn up in tab 14 of the authorities bundle, Lawcom 336, and just a light on a paragraph. The pagination is page 316, and the paragraph is 3.45. The Law Commission say, and with some amendments, the policy has generally been translated into paragraph 17. We take the view that there may be an exception to the concerns expressed in paragraph 3.37 and 3.38. And the concerns expressed there are the concerns of landowners in relation to automatic rights that go too far for sharing and upgrading as a default position without being specifically negotiated. And what is said at 345 is we take the view that there may be an exception and that there are clearly identifiable cases where upgrading and sharing have no physical implications at all and cannot be seen because they are physically confined to a space controlled by the code operator. The obvious example is the addition of a fibre in a duct or subduct, which can be achieved by simply blowing the fibre without any impact on the land. And then at 3.48, we think that the situation where sharing or upgrading take place within the confines of a duct or even of a cabinet on land, without physical or visual impact on the site provider, without requiring a power supply or the addition of an antenna, for example, and without conferring code rights on additional code operators ought to be permitted. These are cases where there is no possible additional burden on the site provider and no technical or safety issues. If, in the case of sharing, the additional code operator requires code rights, it can negotiate these independently with the site provider or apply for them to be imposed. So all paragraph 17 is intended to do, and like all for the avoidance of doubt provisions, it creates an enormous amount of doubt, but all paragraph 17 was intended to do was to make it explicitly clear that if the sharing or the upgrading involved something that was of no or next to no concern to the site provider, that was permissible. Now, it's possible to... Sorry.
Coming back, I've followed that, but even so, presumably, I think Mr. Claimant would say, your client or any other operator could do quite a lot, even living within paragraph 17.
No, unfortunately not. I can take you, for example, to the assessment in the London Quadrant case of that position. If one turns to, I should really take you first of all maybe to paragraph 17, my lord. I'm sorry, before I start putting cases before the court. It's worth looking at paragraph 17, bearing in mind the concerns of the Law Commission and that there are some things that a dongle inside an equipment cabin isn't going to upset anyone, or shouldn't. Now, under paragraph 17, it's provided that an operator who has entered into an agreement, so the agreement is in place, this is not a term but a consequence of the agreement, under part 2 of this code, may, if the conditions in paragraph 2 and 3 are satisfied, upgrade and share. The first condition, this is paragraph 2, is that any changes as a result of the upgrading or sharing to the electronic communications apparatus to which the agreement relates have no adverse impact or no more than a minimal adverse impact on its appearance. Now, or no more than a minimal adverse impact is probably surplusage there because we already have no adverse impact. The second condition is that the upgrading or sharing imposes no additional burden on the other party to the agreement. Now, upgrading and sharing intrinsically fall outside that provision because they will require an additional attendance at site by people who want to install the apparatus, the sharing apparatus, the further apparatus. It will create a different visual impact if another antenna is put up. It will create a different visual impact if a mast is raised or a further equipment cabin is installed. Now, the problem is that the answer that could be given to that is, well, nobody in their right mind would object to that. But people do object to that. People do regard those as outside paragraph 17. And it's precisely for that reason that the site provider in this case wants paragraph 17 to be inserted, or one of the reasons. How paragraph 17 works in practice is probably best illustrated by the London Quadrant case, which is at tab 6 in the authorities bundle. Now, this was an urban rooftop installation. The urban rooftop installation was at the top of a residential building, and the site into which the installation could take effect was a ribbon of land around the roof, a ribbon of area around the roof. So there was an intrinsic physical limitation as to how much kit could be put in there, because as you will appreciate, antennae have to be calibrated so that they don't interfere with one another, and so on and so forth. The argument in London and Quadrant, from London and Quadrant, was that the operator, Cornerstone, a non-neutral host, should be pegged back to paragraph 17 and have no more than that. Now, the analysis begins at paragraph 64 of the law report, page 13. Paragraph 17, the Deputy President explains, is not straightforward and raises a number of problems. One such problem is that it treats upgrading and sharing in the same way, but the right to upgrade, unlike the right to share, is itself a code right. It's not entirely clear whether the right in paragraph 17.1 is intended to be exhaustive. A further problem is that the paragraph includes no explanation as to what upgrade means, and so on. He then explains it's an instance of torrential drafting, and then he records that as a result of litigation since the introduction of the code, as the record of litigation since the introduction of the code demonstrates, uncertainty in this field produces delay, hostility, and expense, and thus undermines the objectives of the code. We bear in mind the risk of imposing on the parties an agreement of uncertain meaning, especially where the uncertainty touches on one of the fundamental purposes of the code, and that's upgrading and sharing. He then records my submission that paragraph 17 is and were intended to be highly restrictive for the reasons set out in the Law Commission report. He notes at paragraph 69 that the Law Commission was not responsible for the drafting of the code, but the view that paragraph 17 is intended to reflect the lowest common denominator for sharing and upgrading, a floor rather than a ceiling, is supported by reference to its report. And he then refers to a number of paragraphs, including the ones that I've taken you to. And he then notes that the Law Commission took the view in paragraph 3.45 that an exception should be made, that automatic rights should be exceptionally allowed for clearly identifiable cases where upgrading and sharing have no physical implications at all, such as the addition of a fibre in the duct. The site provider instead was seeking to argue that paragraph 17 was more benign and that I could do more, or my client rather in that case could do more than I was suggesting. But as the tribunal noted, the problem is that no additional burden is a heavy barrier, is a high hurdle to overcome. And they record at paragraph 17, we do not accept the site provider's submissions. They are inconsistent with the statutory language. And he then goes on at paragraph 76 to identify that really the right way to approach this is to have regard to paragraphs 23.2 to 8, and that the onus is on the party wishing to depart from paragraph 17 to justify its request, referring to the University of the Arts London provision. He then makes one interesting point at paragraph 82, which bears directly on my client. The tribunal say we do not regard the minimal rights conferred by paragraph 17 as appropriate for an agreement between an infrastructure provider and a site provider for a term of 10 years. Both the duration of the agreement and the nature of CTIL's business are relevant considerations. My learned friend is, of course, right that then in the event there was an unlimited right to upgrade, but a sharing right was restricted. So the right to upgrade was unlimited in this case, but the sharing right was restricted. But it was restricted in that case to CTIL's two principal shareholders. And that was the reason for that restriction in that case. The considerations here are, of course, different because Arqiva's statutory purpose On Tower's statutory purpose goes beyond servicing direct shareholders. So, my Lord, that's why, in the view of the tribunal below, paragraph 17 is not regarded as an adequate default, but it is regarded as a useful starting position. But that certainly does not import with it then the suggestion that there is a particularly heavy or special burden of proof which rests on an operator who seeks to explain why that should be departed from.
So just so I'm clear about how far you disagree, you don't accept that you require particularly striking circumstances or something of that kind, but you do accept that the onus is on the operator to show why something more is needed.
Yes, but focusing on the word onus there for a second,
yes.
Some operators might come along and say, we don't mind, what we have is underground ducts, that's all we are, we're a fibre optic cable company, and we're satisfied with paragraph 17, and if we wanted any more than that, it would be entirely surplus to our requirements because we have compressed air guns that shoot cables under canals. But if, on the other hand, you're an operator who has things that are visible above the surface of the ground, that are not concealed in street furniture or under bins or under park benches, but that are masts that sit on top of buildings, such an operator will invariably, inevitably, unfortunately, cause a degree of visual intrusion, works will have to be carried out, and so on. And so, for example, testing it this way, my Lord, if we weren't at a renewal stage, but if we were at the stage of a first installation, would the Upper Tribunal say to Cornerstone or to On Tower or to any operator who requires a mast that the blank site is immediately to be subject to a paragraph 17 restriction, not to upgrade or share? The answer to that is, of course, no. The onus is not heavy. The onus it requires explanation and justification, but certainly the Fotheringham standard, in my respectful submission, is not the right standard of proof to apply.
So you accept the onus is on the operator, but you say it's not a heavy onus?
No, exactly so. The starting point of the tribunal may have been that paragraph 17 is simply there and exists, and an operator might need to explain why more is required, but that explanation does not have any particular weight or evidential burden. It's just how the tribunal has developed its practice, that it's a useful, in the words of Judge Cook in this particular case under appeal, it's a useful starting point, is what she says in paragraph 25 of the judgment. But, in line with what we've seen in the Upper Tribunal in the later cases, it is not an adequate set of rights for an operator engaged in my client's sort of business.
And what about the proposition that the Law Commission and the statute have struck the balance in 17? And of course you want more, and of course they want more, but you can't just say, I want more and therefore I get it.
Correct, absolutely, and that is recorded in the judgment below. I accepted before the judge that just because my client wants doesn't mean my client gets. But in my respectful submission, the error that my learned friend makes in his submissions is to treat paragraph 17 as the alpha and omega of Parliament's assessment of what is required for sharing and upgrading, as if that represents a final balance that governs all relationships between all kinds of operators in all of their activities. That isn't right in my respectful submission. All paragraph 17 does is fix a very low threshold for the operator that says anything below this threshold is acceptable, and you don't have to worry about it, you can't contract out of it. But it doesn't then say, but you can have nothing above. Everything above, as the Law Commission says, has to be either negotiated for, and if not capable of being negotiated, has to be secured from tribunal, either as part of a Part 4 new imposition, or as part of a Part 5 renewal or modification or whatever it may be. In other words, my Lord, I think it's wrong to attach to paragraph 17 the weight that my learned friend seeks to attach to it. it is not Parliament's assessment of where a sensible balance should lie in any agreement. It's Parliament's assessment of what minimal rights are adequate, what minimal rights are unobjectionable. It is simply Parliament saying, well, this is innocuous. Anyone can have this without separately treating for it. But it is certainly not Parliament saying, this is where the balance should be struck in every code relationship. The point that paragraph 17 confers next to valueless rights because so innocuous is made when one looks at paragraph 24 of the code and the valuation assumptions for consideration. Because under paragraph 24, a variety of things are disregarded, and under paragraph 24(3)(b), what is also disregarded in the valuation world is the rights attributable to paragraph 16 and 17, which are deemed not to apply in the hypothetical valuation context. And the reason why they are disregarded is because they are, if I can just use a colloquialism, a statutory, in inverted commas, freebie that has been given to operators who enter into an agreement because they are innocuous, but they are also valueless. If the operator wants to go further than those and seek a term as to sharing or a term as to upgrading, which goes beyond that, then, as the Law Commission point out in 336, that has to be negotiated and then paid for. That's the distinction.
So the extra rights you got form part of the consideration?
Yes. So in an ordinary valuation under paragraph 24, which has always been slightly difficult to understand, but what essentially now happens is that the tribunal will look at the rights that are granted and attach a price to them individually by way of consideration and compensation. And just so that your lordships have some idea of the...
Well, we can see from the reasoning of the tribunal below how they did it.
Yes, I mean, the right that is being debated here is priced at £500 per annum. So before one gets too excited about the extent to which it causes difficulty for the site provider, it's worth bearing in mind that the value of that has been set at £500 per annum. That's the component of the overall annual consideration payable, and there's no appeal on that.
But that's because you've got a no network assumption.
That's because of a no network assumption. But the way that works, my lord, is that, as the Deputy President points out, that's a no network assumption. So you ignore the fact that what's being done is being done in connection with a network, but you don't ignore what's being done.
Yes.
So that the workmen will still, in the hypothetical world, turn up for no adequately explained reason to attach things to a mast that does nothing. So the inconvenience, the visual intrusion, all of that is still present in the hypothetical world. It's just it's not connected to anything.
Yeah.
So that's the sort of background to paragraph 17. It sets a floor to which nobody could possibly object because so low of rights of installation and upgrading. Everything above that has to be separately negotiated and has to be separately paid for. And that's precisely the point that's made by DCMS in the document my learned friend referred you to. When they're talking about the upgrading and sharing rights, they're referring to the automatic right, the statutory default, the statutory automatically conferred right. So my lord, that's how I say paragraph 17 features. Just to give a rather silly example, but if I were as an operator to acquire simply a tree lopping right under paragraph 3 to lop back trees with no other right, I would still get the automatic but useless accompaniment of the right to upgrade and share. It is simply something that follows from entering into something that's called a code agreement, and it's predicated upon a code agreement having been entered into. It is not part of the terms of that agreement, it is its consequence in law. And it overrides any term to the contrary, and if the parties have neglected to negotiate any express terms of sharing and upgrading, it automatically confers them. But what it doesn't do is set a presumptive boundary as to the extent of those rights that are necessary and required. So that's the second point, my lord, as to the appellant's submissions that paragraph 17 is designed to be some calibrated parliamentary balancing act. It isn't. It's a statutory minimum. The third point that's appeared with greater prominence on this appeal is the interaction between the Code and the influences of the 1954 Act upon it, and the relevance of OMA. And my Lord Newey, Lord Justice Newey has referred already to the relevant parts of Judge Cook's judgment in the Mayrick or Chichester case, in which she says, well, of course the 1954 Act influenced the Code, but it influenced it differently in different parts, and one shouldn't simply assume that we have copied and pasted, as it were, statutory provisions and policies over from the 1954 Act into the Code. And the reason why I submit that's of some significance is that my learned friend says, well, OMA should govern, and OMA should require you to look at the terms of the original agreement, and if there's no evidence either way, it's the terms of the original agreement that you default to. Now, there are a few problems with that proposition on this case, and generally. The main problem with that proposition in this case is that neither party wanted the original agreement to continue. My learned friend's clients were contending for a change in the terms of the agreement to paragraph 17, minimalism. My client wished there to be a change towards unrestricted sharing and upgrading rights, noting that under the original agreement there was already an unlimited sharing right, subject to pay-away, which has now been outlawed, and under the upgrading rights, there was an unlimited upgrade right within what was defined as the equipment area, which meant the cabins, and there was then a qualified right outside them. So neither side came before Judge Cook wanting her to impose the terms of the 1999 agreement. So that's what the first point, factual point relating to this case. The second point is that there are very good reasons why one needs to approach with caution the idea that Parliament intended OMA to operate at least in every respect. Under the Landlord and Tenant Act 1954, the outcome of a lease renewal is that one is granted a renewal tenancy on the terms of the original agreement, save insofar as the parties have been able to agree or prove the contrary. Under the Code, the Tribunal has significantly greater powers than that. We've seen the menu under paragraph 34 of the Code. So the Code entitles the Tribunal to do 1954 Act type things, and it also entitles it to do things that are not possible under the 1954 Act. In this particular case, or rather under paragraph 34, the Tribunal is able to strip away code rights under 34.4. It is able to, under 34.5, order that the terms of the code agreement relating to the existing code be modified. So it confers additional code rights, or it provides that the site provider is bound by an additional code right. The court may order the termination of the code agreement and its wholesale replacement with a new one, or it can order that the existing agreement continues until the new agreement takes effect. And plainly, OMA type considerations are going to be more relevant to some of those orders than to others. If the parties have agreed that their future relationship should be governed by an entirely new agreement, as is the case in this case, it's likely that the terms of the original agreement are likely to be less valuable than in a case where one party wants the existing agreement to continue, but subject to some modifications being made. That's the first difference, is that there is a menu of things that the tribunal can do which the county court cannot do under the 54 Act. And that is why one would expect and sees that the OMA principles apply with less force depending on the context. Secondly, the structure of the discretion of the Upper Tribunal under paragraph 34 is different from the structure of the discretion under the county court. Specifically, in addition to paragraph 34.12, in which the court is to have regard to the terms of the existing agreement, It also must have regard to paragraph 3413, which are not features of OMA type reasoning. It has to have regard to the operator's business and technical needs under 3413A. It needs to have regard to the use that the site provider is making of the land to which the existing code agreement relates. It needs to have regard to the duties imposed on the site provider by an enactment, and it has to have regard to consideration payments. So it is entitled, in fact it must in this case, look at the business and technical needs of the operator. It can and must do that thing which on a sort of ordinary OMA application might be said by my learned friend to not be relevant, because it simply looks at it from one side of the coin, what is beneficial in a particular case to the operator. But that is permissible under 3413A. So those are all material differences in the structure and the discretion and the outcome of a code determination. And that's before one, of course, gets to the background of the code, because the code is intended to ensure that technology can be rolled out and kept up to date. And so the needs of operators to ensure that their agreements fit with known and unknown future needs and requirements is a distinct and special feature of this special piece of legislation, which may not be a feature of a 1954 Act renewal of a shop or office, where such change might not be anticipated. So it's for that reason, my Lord, that I would submit that the President of the Upper Tribunal is correct in the Stevenson case, which appears in your bundle of authorities, which I've presently lost. Here it is. Which appears in your bundle of authorities at tab 11. In the Stevenson case, the President of the Upper Tribunal directly confronts the submission that OMA rules, and the point that he makes, just for your note, really is at paragraph 50. He echoes the observations of Judge Cook in the Chichester case that although the 54 Act has been influential, it has not been slavishly copied. There is no doubt, he says at paragraph 52, there can be no doubt that the structure and provisions of the code are similar in various ways to Part 2 of the 1954 Act. He goes on to explain that the provisions of the code are not in any respect exactly the same as those of the Part 2 of the 54, and one must be careful not to read too much based on superficial similarity of structure or language. The purpose underlying the 1954 Act was very different from that of the code, to protect tenants of business premises from excessive cost, business interruption, and loss of goodwill by providing security of tenure, while protecting the legitimate interests of landlords in recovering possession and receiving payment of a market rent. The purpose underlying the code is to ensure that operators can use and exploit sites more flexibly, quickly and cheaply than had previously been the case, at lower than open market rents, in furtherance of the public interest of providing access to a choice of high-quality electronic communications networks. He then refers to Section 35 and OMA and Cairn Place and Wallace Fashions. And then he refers at 55 to the fact that one objective of the code was to change the terms that apply under code agreements where these restrict operators from doing or having the flexibility to do what they reasonably need to do, or where they operate against the public interest. In the code, there is therefore not the same generally applied presumption against change that has been read into the language of Section 35. Rather, site providers are required to put up with a degree of change in the public interest of facilitating the provision of a choice of high-quality networks. And he then adverts to paragraph 3412, which he then says, essentially, where are we? The terms of the existing agreement are intended to be of some materiality, subject to the other considerations. The words of paragraphs 3412 are that the court shall also have regard to those terms. Read in context, this means that in specifying the terms of the new code rights or the new agreement, regard is to be had to the terms as well as the terms the parties have agreed, if any, and the requirements of paragraphs 23.2 to 8, 24, 25, and 84 of the code. These require a new code agreement to contain such terms as the court thinks appropriate, including with paragraphs 25 and 8, including for the payment of consideration and so on.
Does he mention 3413, which you were mentioning a moment ago.
I don't think he does. Sorry, the typing is... No, he does, I'm sorry, paragraph 59. Rather, the court should decide what order to make, taking into account all the circumstances, including the terms of the agreement, but in particular the factors in paragraph 34.13, and then, having done so, specify the terms of the new code right or new agreement where appropriate. The OMA principle does not have a direct role to play in deciding which order is appropriate to make. And he then, at paragraph 61, explains that in relation to Duncan, the Court of Session did not refer to paragraphs 34, 11 or 12 in its judgment, but those subparagraphs do not have the far-reaching effect that APW submits that they do, which in many cases, if APW are right, would prevent an operator under an expired subsisting agreement from applying for a new code-compliant agreement. Now, those observations apply with all the more force in this case, because, of course, what we're renewing is an old code agreement. So not only are we obtaining, not only is it agreed that there should be obtained a wholly new agreement, it is also the case that the underlying agreement to which reference could be had is an agreement which is created and was drafted under the old code in 1999, the terms of which could no longer be replicated as to sharing in the modern law, because the sharing terms are constructed around a pay-away provision which cannot be replicated into the new law because it is rendered void by paragraph 17.5. So, in essence, therefore, my lord, my lords and lady, I say that the effect of all of this is that it is quite wrong to look at OMA in isolation when one is looking at a different statutory regime, using the same words but a different statutory regime, which allows the tribunal to do different things from those things which the county court can do under the 1954 Act, and which has different additional specific elements of the discretion built into it, which are not features of the 1954 Act, and in circumstances in which that renewal provision covers not just brand new code agreements, where perhaps what has been agreed recently might be relevant under 3412, but also agreements entered into many 2 decades previously, where what was agreed between different parties in this case, and with an MNO rather than a whip, as was originally the case under the 1999 agreement, where those are also swept into the new code. So in my respectful submission, OMA may have a relevance, but it all depends on the type of renewal, the type of order that one is looking at.
Sorry, just before you leave E and Stevenson, because when we come back to look at it, if one looks at the held note, I can't find little 2. I can find. I just wonder if I've got a corrupted version.
Held 1. I think the 2 might be buried in the middle of this large paragraph, my lord, because there is a 3 at the bottom. I'll see if I can find it.
Well, just in case, because obviously when one rereads it, we'll make sure that we're reading the right copy.
Yes, I'll check that. I'll check that. My lords, those are the 3 general points that introduce then an examination of the judgment, which has not been closely looked at in the context of this particular appeal so far. My lords and ladies, two things to consider in the first instance. What was common ground before this judge, and what was in dispute before this judge? What was common ground before this judge was that the parties wanted to enter into a wholly new agreement, which I don't need to take you to it necessarily, but if your lordships and your lady compare the agreement as finally determined with the original agreement, you'll see they are completely different beasts. They're on entirely different terms. Now, it is the case that initially the appellant in this case wished for the original agreement simply to continue and opposed there being any sort of new agreement. And that one sees in the supplementary bundle in the first witness statement of Ms. Burrows.
So we can put the authorities away.
Oh, I'm sorry, yes, my lord. For now, sorry, thank you, yes. In the supplemental bundle of Ms. Burrows, you'll see at page 78, tab 7, paragraph 38, that until October 2019 and for some time thereafter, the consultant surveyor for the appellant said that the agreement should continue, that Arqiva, as it was then, should continue to hold over on the terms of the expired lease until such time as it was terminated by the site provider, and that therefore no new agreement should be entered into. That position had changed by the date of the pleadings, because by the date of the statements of case, it had become admitted that a new agreement should be ordered. So that element of the discretion in which the tribunal was required to explore which order to make just didn't arise anymore. It was common ground that there should be a new agreement. A number of the terms had also been agreed. A number of terms were in dispute, as is always the way, but those had narrowed down to a significant extent by the date of the trial. And by the date of the trial, as I've already said, the only thing that was left in dispute was the ambit of the sharing and upgrading rights and consideration. Materially, other things that had been agreed included a number of terms under the lease which protected the site provider in various respects in this case. They are listed in my skeleton argument, tab 4 of the core bundle, page 57, at paragraph 18. And they are terms which the appellant did not advert to below and has not really adverted to in this appeal, but which are the contractual web within which the upgrade and sharing provisions that the respondent is contending for sit. So there is, in relation to any enhanced user of the site, there is an obligation to pay for maintenance of the access track. There is a user clause preventing nuisance and requiring the proper use of the site. There are the usual qualifications and controls over planning and alterations. And there is a specific clause at 3.7 and 8, which arose as follows. In the second witness statement of Mr. Green, for the first time, attention was drawn to the existence of an HSBC legal charge. The HSBC legal charge prevented certain transactions which impacted on the value of the security, and On Tower agreed to the insertion of a bespoke clause in this agreement that they would not do anything that jeopardized that security. So in other words, On Tower have already agreed to adhere to the standards that the appellant itself agreed to for HSBC. There is an indemnity clause, a covenant to comply with regulations, a liability clause, a cost clause for the landlord, an entirely new and bespoke clause for control of access and security, and a new notice requirement for non-emergency access to the site. So there are a series of new contractual provisions contained within the new agreement, which were agreed, which sought to address things like people attending site and coming to the site and doing things that might interfere with the HSBC charge. Those are also all agreed.
I was just trying to look at the draft as you were talking.
I'm sorry, yes.
No, 3.19. In the draft I'm looking at, I can't find 3.19, which is presumably because that got overtaken by something else.
It might. Could I see if somebody behind me can sort that out?
So page 54 of the supplemental bundle goes up to 3.18. I see the 3.19 came along later.
I'll just have to get that checked, my lord. I'm sorry. But those were all therefore agreed matters. Wholly new agreement. Terms were agreed. What was also agreed is the agreement set out at J40 in the judgment at paragraph 48, that the parties were agreed. This is page 87 of the core bundle. The parties were agreed that the fact that an operator wants a right does not mean that it automatically has to have it, and nor is it the case that the respondent can insist on whatever terms it wants. That's the site provider. Both parties argued that the tribunal has a judicial discretion as to the terms of the agreement and must engage in a balancing exercise between the needs of the parties. So that was the exercise which it was agreed that the tribunal should undertake in the course of submissions. And contrary to what my learned friends' submissions were earlier today, it was not the operator's position that whatever the operator wanted it should get. It was an open textured discretion involving a balancing exercise. So that was the common ground before the tribunal. What was the controversial part of it? Well, as I've said, the upgrading and sharing aspects. Consideration is no longer controversial, but just for the court's note, in the judgment at 139 is where the figure of £500 for the sharing and upgrading rights that the respondent contended for is to be found. There were only 2 points which were really controversial between the appellant and the respondent below. The first point was a point of principle, which is whether paragraph 17 operated as a ceiling to the sharing and upgrading rights that could be granted. And that was a point of submission and argument. It was a point that was contended for by the witnesses of fact of the appellant in this case in their witness statements. And then there was evidence of so-called bad behaviour by the respondent. There were allegations that the site was noisy in winter at night. There was an allegation that there had been damage to the driveway on one occasion, but it wasn't sure, nobody could be sure who did it. And there was an instance of a flight of a drone by an operator on behalf of the respondent, which had been apologised for. And then there was a concern expressed that there might be constructed a monstrous mast of huge height painted in day glow with flashing lights upon it. The part of the code that it was common ground was engaged by all of these points was paragraph 23.5. In other words, the only provision that was the subject of any substantive oral submission and evidence at trial was 23 subparagraph 5. It is true that the appellant in this case referred in its skeleton argument to paragraph 34.12, that the terms of the original agreement were to be looked at. But the way in which it was referred to in the skeleton arguments was that 34.12 raised an evidential hurdle that had to be rebutted by evidence called by the respondent.
Do we see that in the document?
We do. I can take you to. It's in the supplementary bundle.
The first or second one?
I think you should only have one supplementary bundle. I think.
I've got 2.
2. Mine are both.
One.
Sorry, it's tab 14.
Thank you. That's in the first.
And at tab 14, we'll see how the case was set out below in the skeleton arguments. And what you will see is at page 182, paragraph 16, pursuant to paragraph 23 of the Code, the terms of the agreement are to be those which the court thinks appropriate for ensuring that least possible loss or damage is caused by the exercise of the Code right. So sharing and upgrading is addressed under the rubric of 23.5, and that's how it was dealt with by the judge and below. And that unfolded as submissions relating to how paragraph 17 worked. And then there was a reference over at page 184, paragraph 20, subpara 3. On renewal but not on imposition of a new agreement, the tribunal specifically to have regard to the use that the site provider is making of the land to which the existing code agreement relates and to the terms of the existing agreement. And all that is said about that is, at the bottom of that paragraph, the rights C seeks are more extensive and require justification. But those are the operative provisions of the code that are referred to in the skeleton arguments. In submission, there was no reference to any specific provision of the original agreement as being in any way relevant to the assessment that was to be made by the judge in relation to which sharing or upgrading right to deploy. And the reason why there was no reference is, in my submission, entirely obvious. It's because the parties had agreed that neither of them wanted to be governed by the existing terms of the 1999 lease in relation to sharing or upgrading. They both wanted something different to happen. And what's more, the 1999 sharing and upgrading provisions could not simply be translated into the new agreement in any event, because they were infected by payaway, which is not permissible any longer, and because the agreement was originally entered into with somebody who couldn't be an infrastructure providing WIP, because those did not exist, or at least were not legally recognised as operators in 1999. So insofar as there was an omission by the tribunal to refer to any part of the underlying original agreement, that was innocuous for the simple reason that neither party thought that was of any relevance. But to be fair to the tribunal, returning to the core bundle and the judgment, she did have regard to the underlying agreement to the extent that she said in tab 6 of the core bundle, page 79, that the original lease was contracted out of the provisions of Part 2 of the Landlord and Tenant Act 1954, that it gave the claimant unlimited access to the site, and you'll recall that an access protocol was agreed to deal with the concerns of the site provider about access in the new agreement, and the rights to upgrade equipment and share the site subject to provision for payment to the lessor. And this is the important bit, as was usual under the old code, that is the code's statutory predecessor, Schedule 2 to the Telecommunications Act. And as one might expect, quite obviously, an agreement from 1999 was calibrated around the old code provisions. That's what it was designed to operate within. But beyond noting that, neither side, neither I nor my opponent below, attached any significance to the original agreement because both parties wanted something different. So that's the parameter of the dispute. 23.5 is firmly in play, and 23.5 is in play because of a desire by the site provider to have paragraph 17 controls because of the belief that that is the statutory maximum, and also because of various factual incidents of what were regarded as by shorthand called bad behaviour. How did the Upper Tribunal approach what was left in dispute? So the first question is, did the Upper Tribunal forget that it was conducting a renewal application? No, it did not. In paragraph 1 of the judgment, it says, the claimant has a telecommunications mast pursuant to a lease granted in 1999. The lease expired and the claimant seeks a new lease under Part 5. So the judge knows that, understandably on the basis of what's said in the skeletons and the notices and everything else, that this is a renewal. There is no specific controversy about the general mechanics of Part 5. Everyone knows what's going on. Everyone has identified 23.5 as the locus of the dispute. The judge notes what is in dispute at paragraph 3 of the judgment. The judge notes at paragraph 9, as I've already identified, what the old lease provided and the context in which it was entered into. The judge then sets out various provisions of the code, including at paragraph 16, 23.5, and paragraph 17 at paragraph 18.
I mean, just before you go on beyond those, it is odd that she doesn't mention Part 5 at all, does it?
Yes, she doesn't mention it.
And to the contrary, she mentions paragraph 21, which doesn't apply.
Which doesn't apply, exactly. That may be because she was looking at the upgrade right as being a code right, and that paragraph 21 imposition might be something relevant to think about. But I'll go on to explain why it is not relevant, why in my submission it was not relevant, but it's innocuous. Because, just a spoiler, because of course paragraph 21 goes to imposition, but the imposition is already a given in Part 5. It is presumed unless put in issue by the site provider in a termination notice. I'll come to that in a moment. This section of the judgment then proceeds to set out the Law Commission materials in relation to paragraph 17, and that's at paragraph 19 of the judgment and following. She then explains paragraph 17 specifically at paragraph 23. And then at paragraph 25, she does the very thing which my learned friend submitted she did not do. She addresses Fotheringham and expresses doubt that what was required was pretty compelling evidence. She says, evidence, yes, but there is no hint in the Law Commission's report or in government policy or the code itself that the rights to share or to upgrade beyond those contained in paragraph 17 might be unusual or generally unnecessary. Quite the contrary. Although, as the Tribunal said in Cornerstone and University of the Arts, the impositions of paragraph 17 is a useful starting point. So she's not leaping in this section to an unrestricted right. She is noting one of her own decisions, University of the Arts London, in which she has described paragraph 17 as a useful starting point, and she has embedded that into the general discussion of the code. So that's paragraph 25. The next section then discusses the disputed terms about upgrading and sharing, and at paragraph 28, she says the second and third disputes are very similar. And what she means by that is that the same sort of issues underlie upgrading and sharing, which is material, of course, because she treats them both under 23(5). And she sets out what the dispute is, and then she sets out in paragraphs 29 and following what the claimant's business and technical needs are. So all of this evidence that she's setting out there as material is directed towards the business and technical needs under paragraph 34 in substance. She then sets out the respondent's concerns with all of that and the reasons for that. And as she notes, this is not the first time that the Tribunal had to have a look at upgrading and sharing. Now, that means that that section covers, my lords, the business and technical needs aspects of the evidence that was before the Tribunal. And she then makes an evaluation of the factual evidence that was before the Tribunal. That's in paragraph 34 and following. She sets out, again, I differ with my learned friend who submits there was no evidence at all. In fact, there are two witness statements of Ms. Burrows and one witness statement of Mr. Halley, in which in some detail is gone into what the general business needs of an operator like Arqiva are, and what the specific plans, insofar as they are known about, are in relation to this particular site.
I mean, in a sense, you're not disagreeing about the extent of the evidence because Mr. Pymont complains there's nothing specific as to the future, and you explain there can't be anything specific as to the future, so you both agree there is nothing specific as to the future.
That is, in a nutshell, an accurate and analysis of where we are. Yes, so to the degree one can know, one can specify, but one can't know with certainty, and that is an uncertainty which the Tribunal is entirely familiar with as being an inherent feature of all of these sorts of cases. She then goes on to analyse the evidence provided by the site provider in this case, and the conclusion that she reaches is set out in the discussion section. In the discussion section, she notes that both sides agree as to the exercise to be undertaken. She then looks at she then looks first at the upgrade right, and she alights on paragraph 21 as being something that needs to be tested. The way in which that seems to have come about is in the transcript. It came about in the context of closing submissions between the Tribunal and counsel then acting for the appellant, in which it was accepted that 21 might, after all, be a relevant thing to look at. It wasn't. That seems to have been the genesis of how this came about in these proceedings. And she does. You're right, and I just have to accept because it says it. She does look at paragraph 21 and the imposition test. Now, my learned friend says that that's where the Tribunal goes down the wrong path and comes to the wrong conclusion, because my learned friend says the Tribunal at that point was looking at things from the operator's point of view first and had to be rowed back from that. But I would submit that that's not at all how the Tribunal was looking at it, because we know from paragraph 25 that she had well in mind that paragraph 17 was the useful starting point, And that was on that basis that she evaluated the evidence and considered the technical needs of the respondent in this case. Now, she goes through the imposition test under paragraph 21, but for the reasons I've already indicated, she didn't need to. And the reason for that is a special feature of Part 5. It's paragraph 31 of Part 5, and specifically it's paragraph 31 4D. Paragraph 21 has no role to play in Part 5 except negatively. The apparatus is already on site and is the subject of a notice seeking renewal or the imposition of a new code right or a modification or a new agreement. And the only way in which paragraph 21 is explicitly put in play is that it is for the site provider to challenge an entitlement to renewal by serving a termination notice invoking the ground under 31(4)(d), that specifically being that your paragraph 21 test would not be satisfied were this to be a wholly new installation. So it is for the site provider to invoke paragraph 21 negatively in that sense.
That's if the site provider chooses to go down this road.
Precisely.
But if the operator is asking for relief under paragraphs 33, 34, it must still be open to the site provider to complain of paragraph 21 type thing.
Well, I was going to come to that because, of course, one of the orders the tribunal can make is the imposition of a further code agreement. And were that to be done in relation to a blank site, that would attract paragraph 21 reasoning. And the point that I was going to make was that it was actually quite reasonable in the circumstance of the tribunal to think about it from a paragraph 21 perspective, because there was a request for an imposition of this particular right in that sense. But what I would say is that it was unnecessary for the learned judge to proceed down paragraph 21, because that is not a necessary component of the Part 5 renewal process. But it's innocuous. And it's innocuous because she determines paragraph 21 in my client's favour, having analysed it, and she then proceeds to consider precisely the correct paragraph that is in dispute between the parties before her, because immediately upon identifying paragraph 21, she then identifies paragraph 23(5) in paragraph 50 of her judgment as then being relevant to determine what shape the the terms to be imposed are to have. She then analyses the evidence which went to technical and business need under the headings of paragraph 21 in paragraph 51 and following. And the finding of fact that she makes is at 52 of her judgment. Sorry, my lord. The finding of fact that she then makes on the appellant's case is at 52 of the judgment. She says that the alarm seems to be exaggerated. There's been one drone flight, so far as known, in the course of a 20-year term, and complaint produced an immediate apology. There is no evidence that flights in the future will be more frequent or intrusive. There's been one incident of damage to property, so far as is known, in 20 years, and it was too minor to be the subject of complaint. There is noise, but again, it has not prompted a complaint until the present reference, and there is now an offer to investigate. And she then discusses she also discusses the tower at 51. We were unimpressed by the assertion that the new mast could be hundreds of metres tall and that safety regulations could require it to be festooned with lights and covered in day-glow paint to prevent aircraft from flying into it. The size of this site, about 67.5 square feet, makes that sort of scenario as practically impossible as it is implausible, but we take seriously the concerns expressed about traffic noise and so on, and that's then explained. But the point to be made, my lord, is that those were all addressed in the evidence of those concerns were all addressed in the evidence of the respondent, and in relation to the respondent's business needs at paragraph 55, you will note all of that evidence was unchallenged. There was no serious challenge mounted to what was said by the respondent in relation to the needs it had in relation to future-proofing the site and the business needs. And the tribunal accepted that difficulties would be caused by capping equipment or limiting upgrading in light of the effect of Compton Beecham and so on. So that's the balancing exercise that the tribunal undertook in relation to that stage of the reasoning. And then the tribunal asked itself, well, is there any reason why we need to modify or limit the rights by reason to the least possible damage principle to the respondent? And she says, we think not. There are ample protections in the agreement, these are the ones I've referred to earlier, combined with the control exercised by local planning authority and the extra protection afforded in the national park. Our answer to that might be different if this were a roof with a specific weight-bearing capacity, or if there were other specific concerns that were not within the protection afforded by the agreement itself or by planning law, but that is not the case here. So in relation to upgrading, therefore, every material dispute of fact is placed before the court. The court considers paragraph 21 and the imposition test. I say at worst unnecessarily, but certainly innocuously. And the court then considers the paragraph that is in dispute between the parties, 23.5, and forms an assessment of the evidence on the facts, forms a view on the business and technical needs from the witnesses which are unchallenged on the part of the respondent, takes a view on the terms of the agreement, otherwise the planning and the national park context, the size of the site, the configuration of the site, and takes the view that these rights, although unlimited as written on the page, were limited and hemmed in by other technical and other considerations, and that was an adequate protection and break on those concerns that were articulated. At para 59, she separately considers sharing, and again she indicates that she is well aware that paragraph 17 is the starting point, because she says, as with upgrading, which has just been considered, paragraph 17 operates as a floor. These are the minimum rights that an operator is to have. It was the Law Commission's intention that if the claimant was to have more extensive rights to share, it would have to be paid for. But that has turned out to be a more limited right than the Law Commission intended, but the right for compensation for any loss or damage caused by more extensive sharing remains. I should add, my lord, that if subsequently things happen on the site which cause damage to the appellant in this case, then there is if what one calls the cut and come again compensation right under paragraph 84. So if something happens during an installation that churns up the track or that causes other damage, the appellant has the right to come back to tribunal if that matter can't be settled outside tribunal to claim its compensation. So there is another layer of code protection that applies in relation to any pecuniary losses that can be compensated during the lifetime of the agreement. And then at para 60 and following, she considers whether paragraph 17 is adequate, whether the rights contended for by the operator are adequate, whether they should be modified again under 23 subpara 5. That's at paragraph 61 of the judgment. She then goes through the various objections that have been raised before her. And at 65, she turns to the unlimited right to share that the claimant seeks. She notes that the business and technical needs and its statutory purpose require that right be given, that it is a neutral host, that there is no need to limit it in the way that's set out in London and Quadrant. And she then concludes, our views on the second will be clear from what we've already said. However genuine the respondent's concerns, they are not reflected in reality nor founded on evidence. And again, she refers to the agreement and planning law and the other protections that are in place. And that's a very long-winded way of saying that 23.5, which was the paragraph that was in dispute between the parties at trial, was considered in both contexts, with the tribunal having firmly in mind, as she reiterates again at paragraph 59, that the approach of the tribunal is to treat paragraph 17 as the starting point. That is what is in the bank.
And that's the issue between you and Mr. Pymont as to that is certainly at the heart of this appeal, in the sense that if the tribunal was wrong about that, then she approached this on a wrong basis.
Yeah, but of course, in my submission, she was right to look at 17.
Yes.
Appreciate that that would be immediately banked by the operator upon entry into an agreement, and then to ask itself, is that enough? And if the answer is no, because it's a statutory innocuous minimum, she's right to look at the wider clauses that are being contended for. She doesn't look at the 1999 lease because obsolete and not relied on by anyone. And she takes the appropriate, in my respectful submission, the correct approach on the basis of the way in which the case is placed before her, which is that the issue is centred on 23.5. That is definitively one of the paragraphs that can be looked at within Part 5, the Part 5 discretion. And within that 23.5 envelope, she appropriately considers all of the factual material relied upon by the appellants, the unchallenged factual material advanced by the respondent, the frank admission by the respondent that it can't provide a shopping list of every piece of equipment that will be on the site over the next 10 years.
What about Ms. Pineap's point that you could have got more evidence from the M&Os?
Well, the trouble with the neutral host, my lord, is that one doesn't know who's coming. In other words, there is already equipment there, but it is completely unclear in a business like this when somebody will wish to put a mast on their site, an antenna on that particular site. Just to give you a concrete example, why would an operator come to this site? Well, it may be, for example, that they lose another site nearby for redevelopment, and suddenly there is an acute need a cell has gone black in the parlance of the industry. There is a black spot, and that cell needs to be lit up again, and suddenly they come to this mast. There is a high element of speculative client interest, if I can put it that way. It is inherent in the business of an infrastructure provider.
Can I just also ask one question about paragraph 51 when she said the size of the site made it impossible to have a 100-metre mast? Was that simply because of the you would need more guys, etc., extending beyond the base of the site to secure it?
Yes, it comes, I think, from both the written and oral evidence of Ms. Burrows, principally. What she says in, forgive me, my lord, I just need to dig around to find it. Yes, what she says in her second witness statement, tab 9 of the supplementary bundle, at page 110, she explains that. So she refers back to paragraph 30 of her first witness statement, so maybe I should go there first. Apologies for jumping around.
No, I'm sorry to have asked.
No.
I couldn't follow it. It was a bit cryptic.
Yes, the paragraph 30 of Ms. Burrows' witness statement says, first witness statement, page 77, there will always be an intrinsic limit of what can be done at a site, not only due to the limited size of the site, but also as changes need to be carried out in accordance with relevant planning. As the site falls within South Downs Park, it has special protected status. Permitted development rights are more limited as a result, and only certain improvements could be carried out without a full planning application. I understand the site provider would be consulted. So that's where she mentions the size of the site in writing, and she then refers to it again at 110. I highlight the site will, given its size and location in the protected area, always have an intrinsic limit to the number of sharers apparatus that could be ever be present. And I think I'm right in saying that in her oral evidence and the transcript evidence, she's asked about that, and she explains that this site probably is about 62 square feet, and that creates an inherent limitation on what can happen. And the reason for that, my lord, is technical, in the sense that antennae can't be placed with whatever density is desired on a mast, because obviously the electromagnetic waves interfere with each other if that happens. So there's a limit to the number of antennae that can be fixed to a mast. There's a limit to the height at which the antennae can be fixed. And if a mast of extreme height is to be built, naturally one would then have to, for example, increase the foundation size. And if the compound is limited, the foundation size can't be increased. I think that is effectively what the point there is.
Thank you.
My lord, I'm conscious of the time and that my learned friend wishes to respond. I had gone through a section of going through the grounds of appeal item by item, but I think in substance that addresses my learned friend, the way my learned friend has advanced his case. If I may just take instructions, see if there's anything else of those.
Yes. So you say the appeal needs to be dismissed.
Yeah.
Mr. Plymouth says, well, it needs to be allowed, and were it allowed, it could be allowed in more than one way. What would you say about that aspect?
Well, my lord, the trouble is, let's take remitting it first, leaving aside, as my learned friend accepts, the cost consequences. And if one excuses the pun, one isn't talking telephone numbers here in terms of the value of the rental payments. There is no additional evidence that my learned friend wishes to adduce. There is no lad and marshal here as something that the appeal court should consider. The court would be remitting back to the tribunal exactly that which it has already considered, and the outcome of that consideration is obvious on the judgment. So, in my submission, because nothing that my learned friend says invalidates the exercise of the discretion by the Upper Tribunal, there's no point doing that. And similarly, my lord, the difficulty that this court faces is that there are findings of fact about the issues that have been placed before the Upper Tribunal. The Upper Tribunal is, of course, a specialist tribunal, which is looking at these specialist matters, and it has made an assessment on the basis of the evidence, the terms of the new agreement, and the planning permission and the various other matters that were placed before it. It would be wrong in my submission for this court to essentially re-evaluate the assessment of the evidence by the tribunal below. So, in my respectful submission, remitting it is a disproportionate outcome, and insofar as this court is sitting in its appellate capacity, it's not, in my respectful submission, for this court to rerun the discretion unless there is some fatal error of law.
That would lead back to the conclusion that the appeal should be dismissed.
Yes.
But just...
I'm sorry. Well, yes.
Suppose that the exercise of discretion by the tribunal were flawed.
Yeah.
And we then had to work out what to do about it. Do we then make up our own minds? Do we at that point remit to the tribunal in a way for the reasons you just expressed? It's a specialist tribunal, it heard the evidence.
Well, my lord, I think that is partially a question of resources and proportionality. I might need to take instructions on that point, but it would certainly be much cheaper from everyone's perspective for this court if it were to be required to do it to resolve the issue.
Yes,
but having said that out loud, I'd better just check
yes.
that nobody's shaking their heads. I think the formal position is that we're neutral on those two decisions, on those two outcomes, my lord. Sorry, I can't be more helpful than that.
You'd rather not get to that point?
I'd rather not get to that point, my lord.
Yeah.
Could I just check?
Yes, please.
My learned junior reminds me of something that I've forgotten. Of course, the outcome, it's worth the court bearing in mind one outcome of a restrictive sharing and upgrading set of rights. Sites are required in particular geographical areas because they're required to provide signal in that geographical area. And if it can't be provided from a site with adequate upgrading and sharing rights, then in this particular location, a likely outcome is that a fresh paragraph 20 notice is served to a site slightly to the left. It's what in telecoms law world is described as the slightly to the left problem, which is that if one cannot do that which one needs to do on the site that is already there, one ends up perforce having to look for an alternative location and duplicate that site.
Just to anticipate, would that be to the benefit of the estate because it would not be on their land, or would it be somewhere else on their land, or can we not say?
We cannot say, except that, of course, it's a large estate and there is a need to have a mast in that general area. So if there is to be, for example, an operator coming to the site and saying to the neutral host, could I bolt my antenna onto your mast? and the neutral host says, I'm terribly sorry, no, because we're not allowed to have another antenna for various reasons, that operator would say, well, I have a need in this location, I will have to build a mast in this location, and that in principle involves looking at something like this estate. So it's a slightly self-defeating limitation in that sense. Yes, the only other point I'm asked to make, of course, is that the only other remedy that is suggested by my learned friend was a series of short-term leases where applications were made to the tribunal under Part 5 for modifications as and when required. That obviously is also a costly and wasteful way of producing a result that could be just as well produced by ensuring that the terms are perfectly adequate from the outset, not least because, of course, every mast site involves an initial financial investment, which is only worth it if there is a sufficiently long-term agreement to justify that initial expenditure. So I think those are the points that I'm reminded to make by my learned junior. Thank you very much.
Yep, thank you very much. Mr. Pymond.
My lords, my lady, I only have a few points to reply. The first is what lay behind the trial. My friend has been anxious to explain aspects of the skeleton argument before the tribunal on our side. It might be helpful also to look at the skeleton argument on my friend's side, because the same problem that we've identified as to the way in which the tribunal approached its task is to be identified from the claimant skeleton. So looking at the supplemental bundle at 1.6, well, starts behind tab 13, 164.
Yep.
And if one turns ahead to 1.6, 6, at the bottom of the page, equipment sharing and upgrading, jurisdiction to specify unagreed terms, whereas here the tribunal is asked under 3610 to resolve disputed terms in the context of a claim for a new replacement agreement under 34.6 of the code. That should be 3410, yes. I think, rather than 3610.
I was just thinking we haven't had paragraph 36.
Yes, right, we haven't seen that. Then the provisions which apply to Part 4 new agreement claims apply as specified in paragraph 3411b. So we start first by the fact that there's no reference to 3412 and 13, which are the operative procedural paragraphs as to the test or approach. And then the skeleton here gets stuck into the cases over the page, which give what's called helpful guidance on terms in those 4 decisions. They include Ashlock at first instance and University of Arts and London and Quadrant, which the court has seen. And then what is said at paragraph 12 is the claimant suggests that the following general principles may nonetheless be derived from the cases. Now, remember, all those cases are paragraph 20 cases. And so the general principle that is sought to be derived, A, is that the code rights sought ought not to be modified unless the tribunal thinks it's appropriate to do so under 23.1. Now, we know that 23.1 is not relevant to a Part 5 application, and nor is, as it were, the code rights sought in the sense that 23.1 uses that expression, where there is a notice for a code right to be given, and 23.1 says the consideration then arises as to whether or not it needs to be modified. So the expression there that it ought not to be modified unless the tribunal, that is all about irrelevant material. And then turning forward to page 172, there's the disputed terms are then identified at paragraph 19, and dropping down to 22a, it said the right to upgrade is a code right in its own right under paragraph 3c. Any restriction, therefore, falls to be dealt with under paragraph 23(1). Again,
It actually says which does not form part of the process under 3411.
yes, exactly, which not form part of the process under paragraph 3411. So we then go on to 175, which talks about the equipment camp. And what is said here is equipment camp is not just outdated, but sets the agreement in aspect and puts it on the certain road to obsolescence during the term. Such caps have now been rejected. B, the right to upgrade is a code right, and the starting point is the right sought in the light of terms and so on. And then C, the same applies to the right to share. In other words, the starting point is not either the existing terms, nor is it paragraph 17. The starting point is the right sought. So going back to my submissions about how the tribunal approached the task, the difficulty with it is that as soon as they lash on to paragraph 21, they're into the wrong mindset. They're into the mindset of what does the operator want here, and is there any good reason why we should have to modify what it wants, which is, in a sense, the opposite of what they should be doing, which is paragraph 17 sets a particular benchmark, and departures from the benchmark need to be justified. So that's my first point in reply. The second point is perhaps arises out of the Stevenson point. Now, the Stevenson case was cited by my friend in a supplemental skeleton argument last week, and we've replied, or 2 weeks ago, and we've replied last week to it. And your Lordship will have seen that raises quite serious issues, at least from our side, as to whether or not Stevenson is right. In fact, as it turns out, my friend is only relying on Stevenson for some observations about the way in which you interpret OME in the context of paragraph 34 and therefore part 5. And in a sense, therefore, that's not the sort of the wider basis or the wider principle that I thought my friend was trying to derive from it. But even in that restricted way, for the limited purpose for which my friend is relying upon it, our submission is that Mr. Justice Fancourt got that wrong. And the reason why we say that is that he failed to follow Ashlock. Well, Ashlock has made it perfectly clear in that paragraph 101, that the OME principle does indeed apply. And the principle is that it, and this is the only principle we need to have for these purposes, is that the principle is that if you want a departure from a particular term, then it is for the party who is seeking it to justify it. And we say that kind of thinking is right with 3412. We say it also works in the context of paragraph 17. But on that limited basis, therefore, what Mr. Justice Fancourt should have done is follow what he'd already been told by the Court of Appeal. And insofar as he was following, as I think he was, the Scottish Duncan decision in the Court of Session in a house, then that also failed to take any account of Ashlock at all.
I mean, Mr. Radley Gardner, doubtless with time in mind, didn't take us to the inner house, but as you're recognising, it and Mr. Justice Fancourt's decision point in the same direction, and your arguments apply to both.
Yes. I mean, for present purposes, if all that my friend is relying upon is those observations of Mr. Justice Fancourt about the way in which OME applies in the context of Part 5, then my answer to it is see Ashlock in the Court of Appeal, which has told us that those principles apply to Part 5, and that is therefore what I'm relying upon, rather than Mr. Justice Fancourt's
I follow that. Mr. Radley Gardner says, well, actually, although plainly 3412 is modelled on the Landlord and Tenant Act, actually, when you look a bit further, there are significant differences, including one of them being that 3413 says the court must have regard to certain circumstances, which is exactly the same formula you get in 3412. The court has to have regard to the terms of the existing code agreement, and the court has to have regard to all the other things. Now, is that a significant difference from the Landlord and Tenant Act?
No, because Section 35 itself says, shall have regard to the terms of the current tenancy and to all the circumstances of the case. Shall I just remind your Lordship
Yes.
of that? That's in tab 12, page 277 is Section 35, which provides that the terms of the tenancy, skipping down, shall be such as may be agreed between the landlord and the tenant, or as, in default of such agreement, may be determined by the court, and in determining those terms, the court shall have regard to the terms of the current tenancy and, at the end, to all relevant circumstances.
The usage, so to speak, 3413 is a more fleshed out version
Absolutely.
of the same point.
That's exactly what it is. It's tracking the terms of Section 35. Well, all it's done is to say, for the purposes of Part 5 application, there are some particular considerations which the court should consider under this heading of all relevant circumstances. And so the court will have regard to those. It does not say that the court shall act so as to accept all the business and technical needs of the operator. It's just a feature of the exercise of the discretion that those matters are taken into consideration. So yes, it does track it. There was one other point on which I think emerged from what my friend said about Stevenson, which is worth commenting on, which is that he said that because the site provider has not put in issue the question of the public benefit condition, then you can take it as read that is there. But then that seems to have been something that my friend is saying should then inform the court's approach under paragraph 34. Well, what I suggest is happening there is that my friend is struggling really hard to give some kind of credibility or basis upon which the court or the tribunal in a case like this should be considering paragraph 21. But it doesn't follow, because if the site provider has not taken the point under paragraph 31.4 so as to put the public benefit point in issue again, then the position is that it is entirely irrelevant to the court's determination under Part 5. It's just an irrelevant position. And a final point that emerged from what my friend said about Stevenson is that he pointed out what Mr. Justice Fancourt said about look at the menu of orders, and the O'May reasoning doesn't help you with the choosing which order to follow to make out of the menu of orders available. Well, yes, but the point about O'May and paragraph 34.12 is that it only relates to cases under 34.10, which are the cases where the court is called upon to determine the terms of the agreement in default of agreement between the parties as to what those terms should be. In other words, it is directed entirely to 34.10 cases, which are termination and renewal cases, and not to the menu. So, my lords and my lady, at the risk of repetition, the way in which my friend approached the judgment was that, as it were, everything is there that you need to find in order to exercise the discretion. The problem with it is that because the tribunal started on the wrong basis, which is paragraph 21 and the conditions that have to be complied. And then moving from there to 23.1 and the modifications to what is sought by the operator. There was a fundamental flaw in their approach. And although matters were then considered, they were considered from the wrong angle and with the wrong idea as to who was bearing the burden of proof. And it's against that background that we really set our case, which is that there was no evidence available to displace the paragraph 17 provisions upon which we rely. And that in those circumstances, with the wrong approach to the evidence before them, the tribunal fell into error and indeed correctly advised, would have come to a different conclusion. So, my Lord, if that letter can be of assistance, I'll leave my submissions there.
Well, that is very timely. Thank you both for very clear submissions. You won't be surprised to know that we will reserve our judgments. They will be provided to you in draft in the usual way for you to correct our typing and grammar, but not to re-argue the case. I would expect that judgment will be handed down remotely, but even were there to be a hand down in court, as I'm sure you know, no one is expected to attend. We'd be grateful if, in advance of the hand down, you would seek to agree an order dealing with consequential matters. If there are any points on which you differ, we'd be grateful for brief submissions on those points, and we would then expect to resolve the points in the order that we make. Thank you both, and thank you those behind you very much for your submissions.